Deputy McLeish, I'm ready when you are.
Good afternoon, Your Honor. Mr. Adams, you're up, sir.
Oh. Hello again, Your Honor.
Good afternoon, sir. Who do you want to call first?
Miss Teresa Villanueva, please.
Teresa Ann Villanueva, CR 21271, set for docket call. Go ahead, Mr. Adams.
Afternoon, Your Honor. Since our last docket call, I've had some conversations with the state about Miss Villanueva's case. I floated made a counter offer to the state's last offer. Ms. Heisel, I'm under the understanding that Ms. Heisel is considering that. And so there's a possibility now greater than last time that this might be resolved with a plea agreement. So I'd ask the court to reset us for one more docket call in the hopes or expectations that that might come to pass.
State.
No objection, Your Honor. We're considering two different options and trying to work this out.
I'd noted that today was going to be the final docket call. Is there a compelling reason why we should reset? Is there a compelling reason why we didn't get it done this time?
I'll follow my sword for that one, Your Honor. I didn't get a counter proposal to Ms. Heisel in enough time for her to have an answer for me today, or in enough time for us to have plea papers ready for today.
Okay. Or we'll set Ms. Villanueva for final docket call again on March 31st. That's going to be on the evidentiary docket. That'll be in the afternoon at the courthouse.
Yes, sir.
Who do you have next?
Rusty Wayne Copeland.
CR 22-6 and 7. Mr. Copeland is set for arraignment.
Yes, Your Honor. Mitch Adams on behalf of Mr. Copeland. Mr. Copeland advises me that he has a copy of the indictment in both cases. Mr. Copeland tells me that the state has properly spelled his name in those documents. He understands the allegation made against him in each indictment. We would waive the formal reading of each indictment or the indictment in each case, enter a plea of not guilty to both charges, and ask to be set for pretrial hearing.
Okay, just 1 second. All right, court will find that Mr. Copeland has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and we will set him for pretrial hearing.
Inside 22.
On April 26th. I think I set you for that day already earlier this morning, Mr. Adams. So if that's okay with you, we'll set it for that same day.
That's correct, Your Honor, and that's fine with me.
It'll be at 1:30 as long as Mr. Copeland is in jail, 9 a.m. if he makes bail.
Yes, sir. Chandler Chafee.
Chandler Chafee, CR 22-4, also set for arraignment.
Yes, sir. Okay. That's right. Okay. Mitch Adams on behalf of Mr. Chafee. Mr. Chafee and I have visited. He has a copy of his indictment. He tells me that his name is properly spelled and set forth in the indictment. He understands the allegation made against him in that document. For purposes of arraignment today, we will waive the formal reading of the indictment, enter a plea of not guilty, and ask to be set for pretrial hearing.
All right, court will find Mr. Chafee has waived the formal requirements of arraignment. Court will set him for pretrial hearing on April 26th. I'd ask the state to ensure that Mr. Adams has access to the online discovery.
Thank you.
Can I get a copy of what? Of this right here?
Get a copy.
Also.
And then, Your Honor, Mr. Shannon McFarland.
Shannon Dale McFarland, CR 2235, set also for arraignment.
Yes, Your Honor. On behalf of Mr. McFarland, Mr. McFarland and I have visited. He advises me that he has received a copy of his indictment, that his name is properly spelled and set forth in that instrument. He understands the allegation made against him in that document. For purposes of arraignment, we waive the formal reading of the indictment, enter a plea of not guilty, and ask to be set for pretrial hearing.
All right, court will find that Mr. McFarland has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and set pretrial on April 26th.
Yes, sir.
Same announcement. He would be set at 1:30 if he's in jail, 9 a.m. if he makes bail.
Yes, sir. Okay. Thank you, Your Honor.
The order that
I
it
need
is.
you to sign right here. Your Honor, I think that's all I have on your docket this afternoon. If I may be excused.
Yes, if that's all you have, then yes, sir. Good to see you. Thank you for being there.
And Your Honor, we do have some other bodies on the way up. It should just be momentarily before they're here, but they're just not here quite yet.
Understand.
Yes, sir, it is.
All right, this is cause number CR 14557, State versus Oscar Robles, set for pretrial.
Yes, sir. So if the court recalls, last court date, we were trying to get some videos. I got those videos yesterday. I'm going to probably need an evidentiary hearing, Your Honor. I went through the court's file again, and Mr. Sickle had filed a motion to suppress. I'm going to go ahead and adopt that prior to that hearing, just for clarity of the record purposes. I'll probably file a written motion asking the court to allow me to adopt that, just so it's clear. So I'd ask the court to just go ahead and set this for an evidentiary matter.
Mr. White, remind me, I see in the file a motion to transfer, or you were asking the court.
No, sir, that's, when we took that up, and Ms. Curry checked that again, just to make sure you weren't on this case. You didn't have anything to do with it when you were DA.
Okay. All right, court will set this for, and you said you've adopted Mr. Sickles' motion to suppress.
Yes, sir.
And when did he file that?
Judge, he filed that sometime in 2017, I believe. I went over it. It's just a very basic motion to suppress. I'm guessing that the main thing, actually, Judge, there's two motions to suppress. There's one for the actual arrest, and then the other one is on a statement. I don't know for certain. If we end up having a motion to suppress, it would be on the issue of the statement. I'm anticipating, you know, I'm not going to say I don't want one on the other one. It's just that I haven't seen the videos yet. And right now I'd probably be inclined not to have a hearing on that, but it would be a hearing, you know, with everything encompassing it. We'd probably end up getting into that a little bit anyway, no matter what, but,
Looking at Mr. Sickles' motion, and it's pretty vague. State, have you viewed that? Do you have any objections to setting for an evidentiary hearing today?
Judge, this case is Ms. Curry. She has been working with Mr. White on that, so I have not viewed that motion. But I do know that that was a common occurrence previously with us having objections to those motions based on their vagueness. But I wouldn't feel comfortable making an announcement right now without consulting Ms. Curry on it.
Judge,
So
if I need to make a more specific motion, I will. But, you know, essentially, I mean, I think Mr. Sickles' motion, as I recall looking at it, you know, is going to, you know, basically deal with the idea that while he was in custody, you know, prior, I talked to Ms. Curry about this actually yesterday, I think, that if there is an issue there that that is going to be on the attorney, his not being provided an attorney prior to giving the statement. I would anticipate that it probably won't be a very long hearing either.
Would you rather do this sooner or later?
Whatever's best for the court.
We can set it in 3 weeks on March 31st.
I think we could probably do that.
Okay. All right, we'll set this for motion to suppress, and I think there was a motion to suppress physical evidence. I would ask you to review that, Mr. White, and if you can narrow it down, it basically asks to suppress all evidence and all testimony of all police officers and anything and everything that was seized or revealed in the investigations. But it's a pretty global motion that doesn't really give us any understanding of what the bearings are about it. So if you could narrow that, the court would appreciate that. But I'll go ahead and set it for evidentiary hearing on 3/31, and that will be at 1:30.
All right. Your Honor, what was the cause number on Mr. Robles' case?
CR 16557.
Thank you, Your Honor.
You're welcome. Good afternoon, Mr. Ashworth.
Afternoon, Your Honor.
All right, this is cause number CR 2349, State of Texas versus Carlton Wendell Mitchell Jr. Mr. Mitchell, if you will, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you put your hand down. Make sure you speak up loudly and clearly today so that I can hear you and so that my court reporter can take down an accurate transcript of what's being said, okay? And Mr. Ashworth, I'm assuming that we're going forward with the plea that's on my desk.
Correct, Your Honor.
Okay. All right, Mr. Mitchell, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, I do.
And have you ever been diagnosed with any type of mental condition?
No, Your Honor.
And in this case, you are represented by your attorney, Mr. Ashworth. Are you pleased with his representation of you?
Yes, I am.
You feel like you've had enough time to discuss the case with him, have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And where you signed in these documents, is that your true and correct signature? And did you only sign once you were comfortable that you knew what you were signing?
Yes, Your Honor.
Okay. And Mr. Ashworth, do you believe that Mr. Mitchell is competent today to enter into a plea?
Yes, Your Honor.
And have you explained to him his legal rights?
I have, Your Honor.
And you believe he understands them?
I do, Your Honor.
All right, Mr. Mitchell, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. That range of punishment for that type of offense is a minimum 5 years to a maximum 99 years or life. Any sentence handed down by a court or a jury upon conviction must fit within that 5 to 99 or life range. Do you understand that?
Yes, I do, Your Honor.
I see that the plea agreement in this case that you've reached with the state is that you would plead guilty to that charge if the state would recommend that the punishment be assessed at 15 years confinement in TDC, a $2,500 fine plus court costs, restitution, and reimbursement fees, and the DA's office would be dismissing 1, 2, 3, 4 other charges that appear to be unindicted. And you would receive 366 days credit towards your sentence for the time that you have spent in jail. Is that your understanding of the plea agreement today?
Yes, Your Honor.
So, Mr. Mitchell, understanding the plea agreement, understanding the range of punishment, do you still wish to go forward?
Yes, Your Honor.
All right. So at this time, Mr. Mitchell, I will ask you, how do you plead to manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams?
Guilty.
And Mr. Mitchell, are you pleading guilty to that crime because, in fact, you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today, Mr. Mitchell?
No, Your Honor.
And the court will accept the defendant's plea of guilt. Mr. Ashworth, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, court's going to review the evidence. All right, the court has reviewed the evidence. I find that there is sufficient evidence to support this plea. The court will follow the plea agreement. The court hereby convicts Mr. Carlton Wendell Mitchell Jr. of manufacture or delivery of controlled substance in penalty group 1, 4 grams to 200 grams. The court assesses his punishment at 15 years confinement in the Texas Department of Criminal Justice. The court will order him to pay a $2,500 fine, $180 restitution, $290 court costs, $120 reimbursement fees. Court dismisses under section 1245 DA which is possession of marijuana, 4 ounces to 5 pounds. DA 2020-763, prohibited substance or item in a correctional facility. DA 2020-760, manufacture and delivery of controlled substance in penalty group 2. And DA 2020-762, manufacture and delivery of controlled substance in penalty group 3 or 4. Court hereby awards Mr. Mitchell 366 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Mitchell, you hereby remain into the custody of the sheriffs and carry out the terms and conditions of the sentence. I'm gonna have you go with the deputy to be fingerprinted. Good luck to you.
Yeah.
Thank you, Mr. Ashworth.
Mr. Knoll?
All right, who do you have with you, Mr. Knoll?
Yeah, this is Brandon Creel.
All right, this is CR 22-8 and CR 22-58. Mr. Creel is set for arraignment on each charge. Have you had a chance to go over the indictment with him, Mr. Knoll?
Judge, we've gone over the indictment. He understands what he's charged with. His name is spelled correctly. We would waive the formal reading of the indictment. We do have in principle a plea agreement in place. We just need to get paperwork done. We've also reviewed the complaint information. There's a misdemeanor assault family violence. We're actually prepared, if the court could do it, to do pleas on those cases next week, if that's possible.
Yeah, next week we do not have any criminal settings. So the quickest I could get you in would be March 31st during the evidentiary docket. It's about 3 weeks. Exactly.
That'd be fine, Judge. We'll get paperwork done and we'll get that executed and be here the 31st.
Okay. Court sets Mr. Creel enters plea before the court March 31st at 1:30 p.m. And that will be here at the courthouse, Mr. Knoll, because it's an evidentiary day. So all the inmates will be brought over.
Okay, thank you, Judge.
You're welcome.
Ted, were we gonna do, has Wood County set up Mr. Crane for his?
Let's see. I'm not seeing Wood County. I haven't seen them yet, but we'll check on that.
Thank you, Judge.
All right, is this Tasha Messick?
Yes, Your Honor.
All right, this is cause number CR 2185, State versus Tasha K. Messick. Motion to revoke. It's my understanding that you have recently been detained, Mr. White.
That is correct, Your Honor. I sent in a letter of representation on Monday. I haven't had an opportunity to speak with the state on any matter related to this. I would ask if we could have something a little bit quicker than the probable April 14th docket. In addition to my typical whining and pouting, I've got a few ideas I'd like to run by the state to see if we can't get this resolved a little bit quicker.
I can set it on the contested docket on March 31st with the anticipation that if y'all don't reach an agreement the next few days or a week or two, that we would go forward on a contested hearing on that day. If we were not going to have a contested hearing on that day, I'd rather not set it that day. I would set it on the 14th.
I said it that day because I'd like to run some of these ideas by them. And I guess if we did result in coming up with some type of agreement, we might be able to move it on there just so we can move her out of the jail here.
So you do want to put it on March 31st?
kind of scared to do that exactly. I'd like to be like I said, I'd like to be able to run some ideas through the state. If
Let's
it all-
do, let's do this then. Let's set it on April 28th. That's the next contested docket after the 31st. And if y'all reach an agreement, then there will be opportunities to plead it on the 31st or the 14th or the 26th. There's some other dates that we can use, but
Okay.
as far as kind of a placeholder for a contested hearing, we'll set it on April 28th. If y'all reach an agreement, you can ask to get it set sooner.
That's what we'll be hoping for, Judge. And I believe that is the only case I have.
Yes, sir. Thank you.
Your Honor, can I have a few more moments to switch bodies again, please?
Yes, ma'am. Thank you.
Thank you. Hello, Your Honor.
Hello. Okay, I see that I have Wood County. I believe they just zoomed in. If you want to go ahead and take care of them.
Yes, sir.
I think that's Mr. Knowles' client.
There he is.
All right, Mr. Crane, let me see if I can get, there you go. Mr. Crane, can you see and hear me okay?
Yes, sir.
All right, can you also see your attorney, Mr. Knoll? Will you wave your hand, Mr. Knoll, so you can see it?
I can see him down, yeah.
Okay, excellent. All right. This is cause number CR 2156, State versus Robert Cecil Crane Jr. And we are set for a pretrial hearing today, Mr. Knoll.
I did go up to Wood County. I think it was on a Sunday. Mr. Crane and I started looking at some of the discovery, and we also had, to be honest, I don't remember if it was on every video or just some of the videos. We had video issues. We have had the opportunity to review some stuff, but not everything. The laptop that I took has pretty much every program for just about every law enforcement agency. But I can't remember the arresting agency, if it was just the SO in this case. But at any rate, we had video problems. So we would need, I guess, another pretrial setting, and I'll get with the state, see if I can figure out if it was just the copies I had, if we need to get it in another format, maybe a thumb drive or something like that.
So you're unable to watch the videos?
Yes, sir.
My recollection is that they would act like they were going to come up, and it didn't come up. So yes, correct. We were not able to watch the videos.
Okay.
And I think most of them are, I think maybe there's a couple of actual videos, and then some of them are interviews of several people. I don't remember how many, but we weren't able to review those.
All right, court will reset this for an additional pretrial hearing, April 26th. I'd ask the state to give it Mr. Knoll and see if we can't figure out the issue.
I'll do
Unable to view the videos. So that'd be at 1:30. We will coordinate with Wood County and see if we can't zoom Mr. Crane again that day.
Okay, and I'll, if I can get working videos before then, obviously I'll get up there and show those to him.
Okay. All right. Any questions, Mr. Crane?
No, sir.
All right. We'll see you back on April 26th. And if the Wood County detention staff is in the room, I appreciate your help today in making this happen for us.
Yes, sir. I apologize for being late.
Hey, no problem. We appreciate your help.
Yes, sir.
All right. You have a good day.
Thank you, Judge. That's all I have, Marvin.
Yes. Thank you, Mr. Knoll.
Thank you, Judge.
And Your Honor, we do have, Mr. Stevens is in the room and ready with two of his clients. If the court would prefer to hear them before the other two that I texted you about earlier.
Yeah, that's fine.
Good afternoon, Judge.
Hello, Mr. Stevens. How are you doing today, sir?
Good, sir. I'd like to do Katie Wiggins first, Your Honor.
All right, Ms. Wiggins, if you'll come forward, please. CR 15-123, hearing on motion to revoke.
Yes, Your Honor, and I received an offer from the state, a couple of different offers yesterday, discussed it with my client, and we want to set it for a plea. And the offer we're talking about is the revocation and then a 4-year straight probation. I was given two different offers, Judge, and that's the one that my client wants to accept.
Which one?
The revoke her, adjudicate her, and put her on a new 4-year probation.
All right, so we can set that.
The earliest date you have, Judge, if possible.
Earliest date I have is going to be the evidentiary docket, which I don't mind doing, but I sure hate to take up all of our time for contested hearings on agreed things, but I'll set it 3:31. That'll be at 1:30, and that'll be here in the courthouse.
Thank you very much, Judge.
I'm not sure if there's an agreement between the state and the defense, but if Ms. Wiggins is going to be offered probation, then I would entertain that if that is for sure the offer, then I would entertain an agreed, PR bond if y'all want to do that.
Well, Judge, if I could talk to the state, that'd be wonderful because she has a 81-year-old mother that has dementia she's taking care of, and then a dad that's very ill too. So that would be very helpful, Your Honor, if she could get out on the PR.
Well, if y'all worked on that together and agreed to it, then you'll just submit it to me. And we can do that without a hearing.
Thank
He
you.
has no objection, so if Mr. Stevens will just email me a copy, I'll forward that to the court.
I'll get a copy sent right over, hopefully this afternoon, Judge.
All right, thank you, students.
Will we still leave her set on 3/31 or will it be a different day?
We'll leave her on 3/31. She'll just need to come in the morning.
In the morning.
Need to come in the morning and then probation will be here and we'll do the paperwork and get that done.
All right, sir. Dakota DeBose, Your Honor.
Dakota Lynn Dubose, CR 21212. It's going to be a plea today, Mr. Stevens.
Yes, sir.
All right, Mr. Dubose, sir, please raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, may I put your hand down, speak up loudly and clearly for me, okay?
Yes, sir.
Mr. Dubose, your name is Dakota Lynn Dubose. Are you a United States citizen?
Yes, sir.
Do you read, write, speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental disorder?
Epilepsy.
Epilepsy?
Sure.
And are you currently on medication for that?
No.
No. Does that in any way inhibit your mental abilities to have a rational understanding of what's going on in this case?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
Yes, sir.
And where you signed in the paperwork, is that your true and correct signature? And did you only sign once you were comfortable, you understood what you were signing?
Yes, sir.
Mr. Stevens, do you believe your client to be competent today?
Yes, I do, Your Honor.
And you've explained to him all of his legal rights with respect to his case?
I did, Your Honor, and in addition to that, I explained the Chapter 62 registration requirements, and I have given him a copy of the Chapter 62 requirements as provided to me by the District Attorney's Office.
Thank you, Mr. Stevens. All right, Mr. Dubose, you are charged by indictment with a second-degree felony offense of sexual assault of a child. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and also an optional fine not to exceed $10,000. I see that the plea agreement in this case is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence be set at 4 years confinement in TDC, along with a fine of $1,500, court costs, and reimbursement fees, and you would receive jail credit of 234 days for the time that you've spent in jail already on this cause. And you understand that by pleading guilty to this and accepting this plea agreement, that you will be required to register as a sex offender for the rest of your life.
Yes, sir.
Understanding the plea agreement, understanding the range of punishment, do you still wish to go forward?
Yes, sir.
All right, Mr. Dubose, at this time, I'm going to ask you, how do you plead to sexual assault of a child?
Guilty, Your Honor.
Are you pleading guilty to that crime because it's true that you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you, Mr. Dubose, to make you feel like you had to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Stevens, any objection to the state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state and with regards to victim notification and compliance?
Yes, Your Honor, the state is in compliance with victim notification. We have not received anything back on file from the victim or her family members in this case. I would also like to address, Your Honor, the mandatory protective order. I texted Mr. Stevens about it. I have filed that with the clerk. However, I've not received back a copy of the filing with a FM number. I don't know if the court has that before them, but I would like to also take up the mandatory protective order today if the court would entertain that.
Mr. Stevens?
No,
All right, go ahead, sir. Go ahead, Ms. Hazel, I'm sorry.
Your Honor, like I said, I have filed for a mandatory protective order until the victim's 18th birthday. Mr. Stevens and I had discussed this previously. My impression from our conversation was that he didn't believe his client would have any objection to a protective order until the victim's 18th birthday. But I don't actually have, like I said, a copy of that back from the clerk for everybody to sign off on yet. It's somewhere in the processing. But the state would respectfully ask the court after the sentence is pronounced to also enter affirmative finding for the protective order and issue that protective order until the victim's 18th birthday.
Mr. Stevens?
I have no objection to that at all, Your Honor.
All right, I'm just going to find that they're, court's reviewing the evidence at this time. So let me finish that and then I'll address the protective order.
Yes, sir.
All right, court's going to find that there is sufficient evidence to convict Mr. Dubose of this offense. The court will follow the plea agreement reached with the state. The court hereby convicts Dakota Lynn Dubose of sexual assault of a child. The court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $1,500 fine, $290 court costs, $85 reimbursement fees. Court awards him 234 days credit towards his sentence for the time that he spent in jail on this cause. Court also finds that based on the evidence that the victim in this case is entitled to the issuance of a protective order until her 18th birthday. Court finds that she is a minor. Court finds that family violence has occurred with regards to the dating or paramour relationship between Dakota Lynn Dubose and the underage victim in this case. And the court will grant the protective order and note that that's without objection by the defendant. So if that will be forwarded to the court will sign that without a hearing. Mr. Dubose, you hereby remanded to the custody of the Banzai County Sheriff so we can carry out the terms and conditions of the sentence. The court also does find that this offense is prosecuted under Chapter 62, requiring lifetime registration as a sex offender. And you are directed into the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. Will be adjourned in this case.
Let's see. Your Honor, I have Mr. Green in the room and Ms. Carter.
Mr. Green, if you'll step up, please.
Good afternoon, sir.
Good afternoon. This is CR 2257, State versus William Joseph Green. Mr. Green, you are set today for a hearing on your arraignment on the third-degree felony offense of escape while arrested or confined for a felony. Mr. Green, the purpose of today's hearing is to affix your identity, make sure that we have the right person on this charge, and then to advise you of the charge, and for the court to find out how you wish to proceed with regards to, are you going to hire an attorney to represent you? Do you intend to represent yourself? What is your plan on how to defend yourself on this charge?
Planning on hiring an attorney, sir.
Okay. If I reset the case today and gave you 30 days or so, do you believe that that would give you enough time to hire an attorney?
I have no money on my books, sir, so there's no way I can talk to anybody.
Well, how do you plan on hiring an attorney?
I've got money in my, I've got money that's owed to me. I'm a contractor.
On a contract? Is that what you said?
Yes, sir.
All right. And so how are you going to get access to that money?
Well, I have to get out to be able to do that. I guess if I can get a court appointed, that'd be fine also.
Well, the thing with court appointed is you're going to have to meet the financial requirements. You're going to have to be indigent. And so before you can get a court appointed, you're going to have to apply for a court appointed attorney. You're going to have to disclose your assets and your liabilities and things of that nature. And then the court's going to have to review that and determine if you are indigent. If you are, then the court could appoint you an attorney and could order you to reimburse the county for that court attorney. So if that's what you want to do, you need to fill out that paperwork and submit that so I can review it.
I've already filled all that information out, sir.
Did you do that today?
No, I did it probably, oh my goodness, been 150 days, probably within the last 60 days.
Okay. Well, I'll tell you what, have a seat and let me see if I can track that down and we'll have a conversation about this.
Okay, good. Thank you, sir.
You're welcome. Who else did you say was ready?
Ms. Carter and Thompson's client.
Oh, yes, Ms. Carter, if you'll step up. This is CR 2204, State versus Anne Marie Carter. We're set for pretrial. Ms. Carter, it's come to my attention that Ms. Thompson, your attorney, has been admitted into the hospital in Dallas. And so she has some health issues that are preventing her from being here today. So I'm going to bring you up and let you know that. I'm going to have to reset your hearing today. Have you been in communication with Ms. Thompson?
No, I've been trying to get a hold of her. I mean, but I can't get a hold of her. I mean, I really don't want to reset. I mean, I wish they'd give me an offer so I could get this up.
When's the last time you spoke with Ms. Thompson?
It's been a couple months.
Has she been to the jail to meet with you and that's when your first discussion was with her, or did you meet on the phone?
We talked on the phone because she was real leery about the COVID, you know what I mean? So she would never come down here. So we just talked on the phone. And I've been trying to call her, you know, since I've been in here this time, but I haven't been able to get her to answer.
Okay, and I don't know how long she's been in the hospital, so that's something that we'll have to take into consideration. But she's not here today, and so I wanted to bring you up and let you know that in person. So I'm going to have to reset your case. I'm going to look into it. If Ms. Thompson is going to be unavailable for a period of time, then I will just appoint you another attorney that can maybe.
Yeah, because I put in another paper for the for a lawyer, you know, the indigent paper that you were just talking about, I put that in when the second day I was in Van Zant. Because I didn't know she was still my lawyer or whatever, but I mean, I don't
Well,
know.
that's, the court received that and the court appointed Ms. Thompson. And so she would be your attorney throughout this whole case, but I'm saying if she's in the hospital and she doesn't know when she's going to get out and be able to get back to work, then I'll consider appointing you a new attorney, but I'm going to have to look into that. And this just came to my attention yesterday.
Okay, and there's no way I'm getting no PR bond or anything.
Not today, not without your attorney being here and being able to talk with the state and do those things. We just don't let people out of jail.
I know that. I just got 3 kids, you know.
No, I don't know. I don't know anything about you. So that's what I'm saying. Without your lawyer here, I can't know anything about you because it wouldn't be proper to have these kind of conversations and things when you're represented by an attorney who's not here. So what I'm telling you is I'm going to reset your case. I'm going to speak with Ms. Thompson. If Ms. Thompson doesn't have time to get out of the hospital and get back up to speed, then I'm going to appoint you a new attorney. And then you contact that attorney and contact the DA's office and we'll see where we're going on this case. Okay. All right. So right now I'm going to reset your case for pretrial on April 14th, and you will receive a letter or some kind, or maybe my staff member will come out and meet with you at the jail. If I appoint someone else, we'll get that information to you quickly. Okay.
Okay, thank you.
I won't leave you just sitting there. Mr. Green?
Yes, sir.
All right, Mr. Green, I've tracked down your paperwork here. All right, so let's talk about this. Let's see. I see that my indigent defense coordinator came out and got your paperwork. Looks like we received one that was about December 27th of 21, and then there was one before that. Now, what I'm seeing here is that you own a home. Is that correct?
I'm
Do
sorry,
you
what?
Do you own a home? Do you own real estate?
Yes, sir.
Okay. And that's value, you estimate the value is at 100,000.
I think with the property, it's 2 acres. It's about 70, between 70 and 100. It's under 100.
And you also own a car outright that you don't owe any money on. Is that right?
That's my wife.
Your wife?
Yes. Does it say what kind of car it is?
Well, it says there's a couple different cars. It says that there's a Toyota worth 20,000.
Oh, that's actually at the dealership, sir.
Well, it said how much you owe on it, and there was nothing written in it. So it looks to me that it was owned outright, and the value of it was 20,000 because you didn't write that you owed anything.
Yes, sir. What happened was, when I bought my new truck, they took that as what would you call it? I owed 9,000 on it. So in essence, I really owe $9,000 on it because they did a bunch of work. They did a bunch of work to it.
So you bought a truck. What kind of truck did you buy?
Sir,
What kind of truck did you buy?
I bought another Toyota,
Another Toyota. What model is that?
2021.
Okay. And so do you own it outright, or do you have a note on it?
I have payment. I believe they took it back. I have no way of knowing.
You believe that that was repossessed?
I believe so, yes. So the only thing that I have right now is a bicycle.
What about, did you ever own a Mazda CX-5? Do you own a Mazda CX-5?
That's my wife. She's in Maryland right now taking care of my grandkids.
Did you ever own a Maserati?
Yes, I did. That was impounded.
Was that a 2020 Maserati?
I just bought it in April.
What was the value of that?
They took that back. It was 80,000. They took that back also.
But you had the money to get financed for an $80,000 car.
We did it on credit.
Well, the problem is, Mr. Green, is that based on the value of your property, you're not going to be indigent. You can use your home as collateral for a loan. You can sell your home. So you're not going to meet the indigency requirements. So you're going to have to figure out how to get someone on the outside to help you access this money that you said that you have. And so that's why you haven't received a court-appointed lawyer.
Okay.
Because you're not indigent at this time.
Sir, what do I do then?
Well, do you have friends or family that you can call?
I have nobody.
You don't have a wife in Maryland taking care of your grandkids. You don't have a son or daughter that's your child that issued you grandkids.
They all left me.
They all left you.
I had a fire at my property. My storage burned down, and as a result of that, she left, and they pretty much. I have no way to contact them or anything.
You don't have anyone else that you know?
No, sir. She pretty much came, I was in a mental hospital for a time. I've been borderline personality, just bipolar. I'm ADHD, AD, and I'm blind as a bat. I literally have nobody.
You said that you're owed money by a contractor?
Yes, he was supposed to do the work on the house, and I came in here, and when I came in here, I haven't had a chance to talk to him or anything. I have no money on the books. I have nothing.
How much money did you give the contractor that you say he owes you?
5,000. He's an electrical contractor.
And do you believe that when you tell him you want your money back, he's just going to give it to you, or are you going to have to sue him to get that back?
I probably will have to sue. Reluctantly, we'll have to sue.
Which means you'd have to hire an attorney. Or you'd have to file it yourself, right?
I'm probably gonna have to represent myself.
All right, Mr. Green, I'm going to reset your case, and I want you to work to see if you can find somebody to help you. I mean, you got upwards of $100,000 that you could use to hire your own attorney. So I'm sorry that you don't have anyone to help you, but you seem to be a relatively intelligent man. You're gonna have to figure that out. So I'm gonna reset you for about 30 days. I'm gonna reset you to April 14th. And we'll talk again on the 14th. And I want you to use the time between now and then on trying to figure out how you can get someone on the outside to help you collateralize your house so that you'll have money so that you can hire an attorney who can help you out of the situation you found yourself in.
Sir, I think it'll be a waste of the court's time to.
Well, see, Mr. Green, I think it'd be a waste of Van Zandt County taxpayers' money for them to just hire you attorney when you got a house, you're buying $80,000 cars, Toyotas and Mazdas and Kubotas and fixing in $5,000 to fix up your house. I think that would be a waste of money. I think that'd be a waste of my time to use their money in that accord. So I'm going to give you 30 days to think about it.
Thank you, sir.
Mr. Green, check the seat. Come on, Ms. Barnes. Mr. Stevens, do you need some more time? Your Honor, if we could have just a few minutes, please.
Yes, sir.
Thank you.
Mr. Stevens, are you ready? Here, let me get you, help Deputy McLean shot. You see on the screen there, if you'll just unmute. We'll need to be unmuted. Yeah, you'll need to unmute.
Now we're unmuted, sir.
All right, CR 2217, State versus Lindsay, Danae Ellis, set for arraignment. Go ahead, Mr. Stevens.
Your Honor, I'm going to advise the court that I've discussed the indictment with my client. We've tried to discuss the issues involving the case. She seems very confused. She doesn't know her birth date. She doesn't know how old she is. She doesn't know how long she's been in jail. And she's unable to discuss with me the actual case. Is an unauthorized use and said the police were driving it and chasing her. So with that being said, Your Honor, I'm a little bit uneasy about going forward with the arraignment, and I'll be following a motion and also support it with an affidavit.
Okay.
And Judge, just for the record, I was just appointed 2 days ago, and this is the first time I've met with my client.
So you're not ready for trial? Is that what you're telling me?
No, sir. No, sir.
Let's see, did I set you this morning for,
I know I got set on the 31st, and I got set, gosh, further out.
are you available on the 14th?
I am, that's April 14th, Judge?
Yes.
Yes, sir, I've got cases in your court that day.
Oh, excellent. Okay. So what we'll do is we'll reset this arraignment for April 14th, and we'll also set it for a status on the competency motion.
Yes, sir.
If we get that filed, then I'll do that and support, like you said, support it with an affidavit, and I'll rule on that without hearing.
All right, thank you, Judge. Is
Do a status on the 14th.
that it?
Yep, that's it, April 14th.
Yes, sir, I got it.
All right.
Thank you, Judge. Have a good evening.
You as well.
All right.
Yes, sir. Okay, sir.
Ms. Chester, are you ready? Deputy McLeish.
I am not on the call this
Sorry, Judge.
afternoon.
I was just talking to you like you could hear me, sorry.
It's okay, I'm not a very good lip reader either, so I don't have that superhuman power that you women have to be able to do that, so that's not bad.
This
All right.
is Simpkins.
Yes, I know Mr. Simpkins. He and I went to school together. We were friends, and so I do know Joey pretty well. So this is cause number CR 21245, State of Texas versus Joseph Wayne Simpkins. And Mr. Simpkins, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. Make sure you put your hand down. Make sure you speak up loudly and clearly. My court reporter's on this end. She's going to be taking down everything that we say. All right, Mr. Simpkins, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition?
Depression.
Just what?
Depression, that's on my.
Depression. And are you currently on any kind of medication, undergoing treatment for depression?
No, sir.
All right. And do you believe that that is in any way affecting your ability to understand what's going on in this case? No? Okay. All right. And in this case, you're represented by your attorney, Ms. Casey Chester. Are you pleased with her representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with her and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand? All right. And for the record, you shook his head no. So just make sure you say yes or no for me. And so in this paperwork where you have put your signature, is that your true and correct signature? Did you only do that once you were confident you knew what you were signing?
Yes, sir.
Okay. All right. And Ms. Chester, do you believe that Mr. Simpkins is competent today? And have you explained to him his legal rights with regards to this case?
I do, and I have, Your Honor.
All right. Do you believe he understands them?
I do.
I see here that Mr. Simpkins is charged with a state jail felony offense of possession of a controlled substance of penalty group 1 less than 1 gram, which carries a range of punishment minimum 6 months to a maximum 2 years in state jail or prison. And I see here that the plea agreement is that he would plead guilty to that, and the state would be recommending 9 months confinement in state jail, with Mr. Simpkins receiving 2 days credit towards his sentence for time that he spent in jail on this cause already. In addition, he would have a $1,500 fine plus court cost restitution and reimbursement fees. Mr. Simpkins, is that your understanding of the plea agreement?
Yes, sir.
All right. And Ms. Chester, yours as well?
Yes, Your Honor.
All right. So, Mr. Simpkins, at this time, I ask you, how do you plead to possession of a controlled substance, penalty group 1 less than 1 gram?
Guilty.
And are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
All right. Court will accept Mr. Simpkins' plea of guilt. Ms. Chester, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest the case this time.
Thank you, Mr. Woodwhite. Anything further, Ms. Chester, from the defense?
Nothing else from the defense. We rest in close as well.
Okay, the court will review the evidence. All right, court's reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Simpkins of this offense. Court will follow the plea agreement in this case. Court hereby convicts him of possession of controlled substance, penalty group 1 less than 1 gram. Assesses his punishment pursuant to the plea agreement at 9 months confinement. The State Jail Division of TDC orders him to pay a $1,500 fine, $290 court costs, $180 restitution, and $35 reimbursement fees. The court awards him 2 days credit towards his sentence. for the time that he's spent in jail on this cause. And Mr. Simpkins, you hereby remain into the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go over with Deputy Police to get fingerprinted. After that time, I wish you the best of luck. All right, is this Mr. Fulco?
Okay, that's correct, Your Honor.
All right, this is cause number CR 2219, State versus George Walter Fulco, and we are set for arraignment.
That's correct, Your Honor. Mr. Polka has informed me that his name is spelled correctly on the indictment. He understands the charge that he is being held on. At this time, we would waive the formal reading of the indictment, enter a plea of not guilty, and ask to be set on the pretrial docket.
All right, court will find that Mr. Fulco has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record and will set this matter for pretrial. Do you prefer April 14th or 26th, Ms. Chester?
Can we do the 26th, Judge? I might be in jury trial the 14th.
Yeah, that's probably when I sent you this morning, isn't it? I didn't.
Yes, I think that's right.
All right, we'll set them along with your other cases for pretrial on the 26th. Mr. Fulco, if you make bail in this case, your hearings will be at 9 a.m. at the courthouse. If you remain in custody, then your hearings will be at 1:30 via Zoom at the jail, okay?
Thank you, sir.
You're welcome.
So you just need to decide. I would want them to have the time.
And just for the record, CR 21-319, State versus Tasha Marie Bells. Mr. Sawyer filed a motion for continuance due to him being in trial in Smith County. And the court granted that and has reset arraignment to March 31st.
Your Honor, I think we've run and completed the jail docket. Is there anything I can do for you before I check out here?
No, ma'am, I don't think so. State, do you have anything else?
No, Your Honor, I believe that's all that I show in my docket as well.
Okay, all right, we'll be adjourned.
Thank you, Your Honor.